Welcome, ladies and gentlemen. Thank you for joining us this afternoon. My name is Brenner. I'm CEO of Licensing Consulting Group, and I'm here with Jose Herrera for Licensing Strategies for Latin America. And today we're going to introduce you to Latin America, talk about what the licensing opportunities are, some of the IP laws, how you do contracts, and what some of the opportunities are in Latin America. So to begin this presentation, let me take you through what we're going to cover. We'll start with some introductions about myself and Jose. As I said, we'll talk about the opportunities, IP laws in Latin America. One interesting point that Jose will be covering is structuring licensing agreements. It's a point that's very important to understand that there are some specific government regulations down there that make structuring agreements a little tricky, and Jose is going to take you through that. Then we'll comment on, finding and qualifying licensing partners, some of the things to look for, how you manage your partners in Latin America, and we'll wrap it up with your question and answers. And as we go through this workshop here this afternoon, feel free to put your comments in the chat box. So let me begin with a quick introduction to myself. For many of you who don't know me, my name is Brenner. I'm CEO of Licensing Consulting Group. My focus is on helping companies to make money with their IP, managing licensing programs for them, doing strategy consulting work, as well as audits to figure out what you have and how to use it. I got my start in the entertainment business way back when, in the days before entertainment really had licensing as a front revenue generator. But in that time, I really learned the licensing business from the consumer product standpoint and saw a lot of things, a lot of crazy deals, and had a lot of good experience that I've since then transferred over to the technology side of the business, and now do a lot of work with medical devices, consumer technologies, trade secrets, formulations, and other types of IP. So with that, let me turn it over to Jose. And if you would, Jose, give us just a brief introduction about yourself and what you do.
Thank you, Rand, for the invitation. I'm really glad to share the workshop with you today here. Well, my name is Jose Roberto Herrera. I'm an attorney from Colombia. I'm the partner of Herrera, Díaz, Abogados. That is a boutique law firm in 3 fields: in IP, in intellectual property, and in entertainment law, and in media law. Our main services are mostly related to filing and litigation and drafting agreements in these areas. Yes, our main clients are from the entertainment industry, the technology, and the media and food industry. Those are like our core business, our core clients, such as for example, the Entertainment Software Association, the ESA, that is located in US, that they associate all the publishers for video games. We have a strong practice for video games, so usually we help them to draft agreements for different Latin American countries with different video game developers. Other client, the national client, is FedeSoft, that is the Colombian Software Federation. And we also work with some football teams or football leagues here in Latin America, in Central and Latin America, many agreements mostly related to publicity rights. A brief introduction about me is, I am an IP attorney. I started my work in 2004 when I got my bachelor's in law here in Colombia, and I work in the private sector, and I made one of my first practices in the Colombian Copyright Office. I did my LLM in 2007 in Germany, in Munich, in the Max Planck Institute. That is a really nice place to study IP. And since 2011, I found Herrera Díaz Abogados, that is my law firm here in Colombia.
Well, thank you for that introduction, Jose. I think a lot of people will now have a good understanding of what you do and how you can help them. So let's move on in the presentation here. And I think the starting point that we want to comment on here is really what's going on with IP licensing in Latin America. I think, for understanding what's happening, Latin America is a growing market. You're obviously down in Colombia, but the region as a whole has been growing dramatically. And so there is a lot of demand for innovation down there. In fact, I know that in Colombia, you've got a lot of technology companies, a lot of startups, a lot of innovation going on. And all of this is in response to, the growing population, the increasing wealth down there, more companies looking to do business down there. What do you see from your perspective? I know you do a lot of work in the media, the law. What are some of the opportunities that you've seen growing down here, and things that companies here in the U.S., startups in the U.S. could really be looking at in terms of possibly considering Latin America as an opportunity to expand their business through licensing?
Yes, that's a really good question, because from what I have seen in the last years, when I started filing trademarks, for example, for foreign companies, is that sometimes they file just to have the trademark, but they are missing many opportunities because they are not using, well, I'm not saying all the companies, but a major part of companies, of US companies or European companies, and big companies, multinational companies, that they usually file their trademarks in Latin America. But I believe that I don't have these statistics as such, but from what I have seen from my perspective, I believe that it can be like 30% of the filings are not in use, because in many of the Latin American countries, you have the possibility of filing a cancellation action due to non-use if the right owner is not using their trademarks or even their trademarks. So that's why one of the things that I would like to mention in this workshop is the opportunity of licensing for those companies that are not using their IP, because some big part of them are not using, despite they are registering their IP. And in Latin America, like a big panorama of the countries that are using or that are growing in technology or in their economies, at least in the media and technology industries, are Mexico, Brazil, Colombia, Argentina, and Chile. These are the biggest, at least in software and video games. These are the countries in Latin America where the growth has been bigger than in comparison to the other countries. Also because of the population that is bigger in these countries, and also because of the economy. Despite some public order issues, these countries at least maintain some economic growth. And in the case of Colombia, it is important to mention that that one of the main flags of the current president, Iván Duque, is what is called the orange economy. That is an economy, in other words, is the economy directed to the creative industry. And this is why in Colombia, it is really important right now, the intellectual property and the license, the assignments, all the intangibles goods. So this is a field in which licensing is really important nowadays.
And it's great. So you're saying that there's an opportunity here, demand for content, entertainment content in Latin America. So there could be so it presents an opportunity for anybody that's looking, let's say, in entertainment. They want to expand into a market. Latin America has got a lot of demand for it, and licensing partnerships would be the way to go.
Yeah, exactly. And
these companies.
Exactly, and with franchise, for example, as well in the food industry, many franchises are entering in Colombia right now, and in other, well, Mexico, and that you are near Mexico, but many franchise and new trademarks, US trademarks, are entering here. So it's a big opportunity right now. Despite some things that you can see in the news about public order, I believe that this has been a problem of 20 years. But in the last 5 years, the economic growth, especially in this field in IP, it has been really, really high. So this is I believe that this is a big opportunity, because the market is growing in this field. As you have seen the oil, that in Colombia also it was a business, or Venezuela, that is really a problem right now, but the oil that is not really, that is in crisis right now. So all these trademarks, the copyrights and patents as well are increasing as well their growth.
So for anybody that's looking, such as, like, for example, medical devices, technology, healthcare, a lot of that has been, you know, a big focus here, but I imagine down in Latin America, there's also a huge market opportunity that that licensing would be a great way to come down there with, whether it's monitoring devices, drug delivery, whatever the case is. I would think that there's probably a huge demand down there for it.
Yeah, a lot, and especially because these products are not produced here. Usually they come from Asia, US, or Europe. And I have seen, because we had filed some trademarks, and we have also filed some health requests, like the FDA in US.
Right.
For example, here is in the INVIMA is the name of this authority here in Colombia. Many of these devices, for example, for the COVID, has been also registered, these trademarks or this permission for the health before the health authority. They're also really it's also a big market here right now for and also an opportunity to license, because many of these companies are looking for national companies to help them to distribute their product.
And you're talking about companies locally there looking for products to bring in to Latin America.
And especially for COVID, I have seen many from China. All these tests for the COVID and these respiratory devices. I have seen some from Europe in the last days, but of course they are from US also. I have the big issues right now is this is going to be in all the world, but especially the patents that are covering the COVID treatment or the future vacuna, the vaccine. How do you say that in English? The vaccine.
Okay.
The injection that you put
the vaccine.
Vaccine. Yeah.
Yeah.
That's right. Exactly.
So companies that obviously here in the U.S. that have been developing technologies, they should take a hard look at what's going on down there, because there could be some big opportunities for them to find partners. I know there's some big companies that are going down. A lot of big U.S. companies are going down there. I think that more startups here in the U.S. need to take a look at it, because it is growing, and you're right there in the backyard. So they could certainly have somebody as a good legal representation to help them maneuver through finding the partnership, which we're going to talk about a little later on.
Yeah, that's right.
So let's move forward then and talk about that. In speaking about the laws here is, obviously one of the big questions, especially folks looking from the U.S., or how are IP laws in Latin America? What does it take to register? How do you register, and how do you protect your IP in Latin America?
Okay, good. In Latin America, only some countries had approved what is called the Madrid Protocol. That is an easier way to file trademark applications in other parts of the world, because it simplifies the process with only one international application. You can select some of the countries to get the registration instead of hiring an IP or a trademark agent in each country. In the Latin American case, we had the Madrid Protocol accepted or approval, now working in Colombia, in Mexico. I know that in Brazil and Cuba, but it's not that much of the countries that have this protocol in their national laws. So usually for Latin America, you have to share for an agent to file. In our firm, we have different correspondents in different jurisdictions, Latin American jurisdiction, and can help U.S. companies to file their applications in Latin America. Perhaps one of the, I think, maybe can you share me the screen and I put you
you have something you want to share on.
Yeah.
Are you talking about the contracts now that we had talked about earlier? Or you have something else?
Right now, I'm going to talk about just in general of filing IP, but then about licensing agreements, I can talk later.
Let me just figure out. Okay, so you want to share something. So let me
Yeah.
Okay. Hold on a second here. Let me figure out how we get other shares here. Okay. Hold on a second. So pause the share and okay. Just bear with me 1 minute. I'm trying to figure out how to get a new share going here. Okay. Let's see here. So what you want to talk about, why don't you go ahead and just give
Okay, good. Well, in Latin America, yes, that you usually you have to hire an attorney, a local trademark agent to file, or a patent agent if it's a patent, or a copyright attorney if it's a recorder of a copyright work. So usually here, what is important to mention is that we don't have the Madrid Protocol approved, so we have to choose an attorney or an agent specialized in a country. The filing it is not that easy as in US, because in US you can do all this procedure online. In Latin America, only few countries have this opportunity to file online. Colombia is one of these countries. Colombia, Chile. I think that in the region, Colombia and Chile are the example of good trademark offices, as they are really fast in the procedure, and you don't need to file, for example, a legalized power of attorney or a notarized power of attorney. But in general, in comparison to other jurisdictions, you have to file on paper. You have to send your papers, your power of attorney, or for example, if it's a license, you have to send them on a courier, and then.
Jose, you should be able to share now. So if you want to put up your.
Yes, this is just some points that I.
Okay.
That I made. Can you see these points?
Yes.
Yeah. Okay. Yes, it's just some points for me to guide a little bit. So I was telling that in Latin America, you don't need you will have to in the majority of countries, you will have to file on paper documents, because there is not that easy the online filing. Here, of course, in many Latin countries, when we are talking about patents, there are compulsory licenses. But here we are not going to talk about compulsory licenses, only like voluntary. That is when the trademark or the patent owner or the copyright owner voluntary license to a third party this IP. One big difference with common law countries like US, UK, is that in Latin America, their major part, with the exception of some UK colonies, our main law, our main source of law is the statutes provisions. It's not like the common law that as you know, in US, perhaps you have many decisions of trademark license agreements of US judges that has the same value as the statute. In Latin America, usually the law is the most important, is the main source of the, in the pyramid of law. This is the main hierarchy. The law is the main one in which we will have to consult if we have any kind of issue. But the tendency, of course, in many Latin American countries is that the judges are also having many decisions that are almost like law. So this is like a paradox, because with the coming of years, also many things that the judge says are also important right now in Latin American countries that are being precedent, what is called the precedent. So what I was telling in the beginning, that the big part or the important part of the tip or the recommendation that I would like to give you is that if you know companies or have a company that is filing in Latin America, is to check if they are using this IP because if not, the recommendation is licensing, because in my practice, I have seen many trademarks or patents that are really registered here, but no one else is using it. So perhaps this is like the main point of growth and opportunities.
You're talking about, the point is there's a lot of good patents that are there, a lot of proven technologies, but the patent owners don't know how to commercialize it.
Yeah.
So there's,
and sometimes it's enforced as well, because sometimes they don't hire any surveillance service to check if there is somehow some kind of infringement. So this is another opportunity, because also they register and then they disappear because they don't, of course, this is not all the companies, but some of them, they just want to have the patent registered, but they are not doing anything else.
yeah, they're innovators, they're inventors, and you see that a lot here in the United States. There's a lot of people that are real good at innovating. They develop a patent, they file it, but they don't do anything with it, which is the reason why most patents never make money, get commercialized. But I think this is an opportunity here, especially for entrepreneurial companies who are looking at for new innovation. I mean, you could go into Latin America, for example, find some of these patents that are market ready, be able to put a license deal together and bring this new technology into the market with your expertise. So rather than going through the whole, trying to R&D and import and figure out if the product is going to work, you've got an opportunity to work with some local inventors or innovators right there in Latin America. And that in itself could present actually a profitable opportunity, especially if the technology is market ready, and you can set up the sales channels and get it into the market relatively quickly.
Yeah, exactly. And you make me remember that there are many hubs here from entrepreneurs that they check some technology that is registered but not in use, and they have this bridge to contact these entrepreneurs with the foreign companies that have the rights registered in Colombia. So this is another. For example, there is one called Bogota Hub. That is one of these ones that I know that they usually check future opportunities with IP, with registered intellectual property, in which they can check if they can make some agreement in order to exploit these inventions or even the trademarks, or for example with the food industry, with many franchises.
So there's an outreach. So you've got down in Latin America, they want to partner up. They're looking for partners. And I imagine, especially with the expertise, the entrepreneurial expertise, to figure out how to get it into the market.
Yeah, or it can be also the other way that is many. I'm a professor in one university called Herrera in the industrial design career. I teach IP there, but there are many inventors that they don't have the money. They usually invent industrial designs or patents or utility models, but sometimes they look for US companies to have capital they usually assign their IP, but they usually get paid for one invention or a design. So this is the other way around.
Okay, good stuff to know. So really, I've talked about this, more on the US side, but really this whole idea of licensing and innovation, you don't necessarily have to own the IP. I mean, you could have the expertise and know how to commercialize it. And there's lots of innovation that's just sitting on the books, like you said, patents, that they need people to partner with them. And oftentimes I found that the inventors don't even know the first place to go to try to find those partnerships, or sometimes they attempt to do something on their own and usually get in trouble. But I think that the point that you're making here is there's a lot of similarities down in Latin America, and there's a lot of good technology that's sitting on the books. And so for anybody listening who's thinking, wow, what are the opportunities? I mean, one of the opportunities is to go down there and find some of these technologies, see if they are market ready, put a license agreement together, not only for Latin America, but also there's the opportunity to bring it back up into the US if in fact it's something that's innovative enough to reach out beyond the Latin American market, which most of the time they usually are. It would depend on the category, but I would think that there's probably a lot of slick IP being developed down in Latin America.
Yeah, and especially right now the software industry, as I mentioned, in Colombia, there is many talent, not only Indian engineers that are usually the Indians have really good fame of they're good developers, but in Colombia right now in a part called Armenia there is a big hub of developers and the tendency for foreign companies to have agreements, to sign agreements with them so they can develop video games or software for apps is really high. um, right now, I would like to explain a little bit about how the particularities of these license agreements that you have
Sure.
to take into account in
Okay.
when signing with somebody in Latin America.
Okay.
Usually, well, these agreements, the law doesn't say it as such in many jurisdictions that they have to be written, but the recommendation is that that you have this agreement in written agreement, because you have to, in some countries you have to register these agreements in order to have effects on before third parties. This, in other words, means that if you register this agreement, and for example, if you are a licensee and you don't register the agreement, then you cannot sue if if the
That's an
agreement is
important
not
point.
exactly. And in major part of, I know that in US you cannot, it is not mandatory, but in some, I think that it's only like 2 or 3 countries in the entire Latin America that there is not an obligation to register. Here in Colombia you have to register this agreement in order to have the effect before third parties. Another particularity is that the major part of these countries, Latin American countries, they need paper documents, legalizations, and authorizations. For example, if you hire me to register or to file a trademark here in Colombia, there is not a problem because everything can be sent online. We don't need authorization on legalization. But I believe like 80% of the Latin American countries, you will have to ask the client for a legalization of the power of attorney, and an authorization as well, because it's not only enough for in some countries to legalize the power of attorney. You also have to notarize before a public notary, and this is a one big difference, a cultural difference that I would like to point out in comparison to US, because I believe that in Latin America, sometimes with all these troubles that you see, or sometimes we start like presuming the bad faith of or the other party, and that's why we usually need to prove with a notary that the people that is sending you the documents is the one that is telling you. So this is like a different conception, because maybe we have to be sure, and all these formalities, in my opinion, these formalities should not exist, because it's really in the work that we are living today, it's really absurd to ask for a legalization of a power of an attorney. And I think that this is also sometimes a business for many notaries. So I think that for this type of agreements, they should not require these formalities. But yes, in the end, you have to do it in many countries to have this filing in paper, the legalization and notarizations. Other characteristic is that there is only few online filings. All these
I think
license agreements.
that's
Mhm.
it's an important point to bring up, because it is a big difference between what Latin America and in the United States, we have contract law here, and it doesn't require the registration of a license agreement by any government agencies. I mean, obviously the IP is licensed and registered, but contract law is valid, and contracts are valid, and contracts then court system is used to enforce the terms of the contract, but it doesn't require a government registration. And I think that many times companies or entrepreneurs go into a country such as Latin America and assume the contract law is the same. And this is where they can get tripped up, especially if they form a license agreement, they don't bother to register it, and then something happens and they go to enforce it. Suddenly they don't have a license agreement. And
Yes.
that's one of the reasons why, we put together this workshop, because it's important to understand that while there are opportunities in Latin America, the regulation, especially on the contract side, is something that you got to be aware of and can trip you up if you don't pay attention.
Exactly, and that's why I made this chart below that I will send it to you if you want to share it with
Yeah, we can share that with everybody after the conclusion
with,
of this presentation.
I will not have the time to explain all the details, but here I put like four points. For example, the first one is our license agreements regulated in law. One big particularity is that these are in-nominated agreements. That this means, in other words, that the law doesn't have like a chapter of license agreements. In some countries they have, but the general rule is that in this license agreement, the parties have a lot of freedom to negotiate different conditions, because the law doesn't regulate, for example, how much would you have to pay for a royalty or many other conditions. But this is the general rule, like a freedom to negotiate, because in general the law doesn't regulate this. There are many things that are, in some countries, they are competition law regulation, in which for licensing is not allowed to make some kinds of behaviors that can affect the competition, that can be against competition. So this is why
so you're saying anti.
You hear names like patent pools or copyright pools in order to protect the market. So the license provisions that you usually see in these countries are more directed to these provisions to protect their market, rather than a private interest
Okay,
provision.
interesting.
Mm-hmm.
Okay.
And the other regulation that is seen in in Latin American countries is the taxation. For example, there are some things that are I'm not an expert in taxation. We have somebody in the firm that help us with that, but I know that, for example, with royalties, there are some in some countries there are some provisions that you cannot have that freedom as much, because you have to do many things concerning taxation and technology transfer agreements. There are new regulations about this. So this is like the competition and taxation issues are the ones that are usually regulated. But in general, the license agreement is really open in all these countries, meaning that the parties have many freedom to negotiate different conditions.
That Jose, let me ask you, going to this
Mm-hmm.
to this royalty question, is, and you said there's a lot of freedom there. When putting together license agreements in Latin America, you got royalty payments. Now, is it a situation where you can be U.S. based, do an agreement in Latin America, and those royalties can be sent back to the U.S. and then obviously deal with it under U.S. tax laws, or is there a situation where there has to be some intermediary in Latin America, whether it be a company, a joint venture, or something, before those royalties can be paid back into the U.S. IP owner?
Yeah, I remember that, for example, in this case, China does not allow, but in general,
Right.
in the Latin American scenario, there is not that restriction. Of course, there are some taxation issues that you have to pay the tax as well in the country, and there are some countries that have this double taxation treaty to prevent the double taxation. But the general rule is that it's not as rigid as, for example, in China.
Right. Okay. But this is something, so, in working with licensing agreements, it's pretty straightforward, but this is an area where, depending on what country, you work with your clients to make sure that if there is those little caveats, those are put into the agreement, so that it's not, it doesn't get tripped up with we can't pay you because the agreement isn't properly structured.
Yeah. Fortunately, in my experience, I have not seen this in at least in Colombia, because usually we recommend other attorneys or
Right.
for other Latin American countries, but I don't have seen this, fortunately, because I in comparison to from the experience that I have seen that I have heard in Asian countries, that is more difficult. So,
it is. I can tell you from personal experience, it is. So it sounds like doing business in Latin America is much easier. There's still some caveats. So, Okay, why don't we, go forward with the rest of what you wanted to cover here under the
Yeah.
contract, because I want to talk a bit now, next up about talking about some licensing partners and qualifying,
Okay, so
things like that.
here I didn't include all the Latin American countries, but the main ones. One important thing is that usually in Latin America there is not a like in Europe, you have the communitary regulation, the European community regulations, but in Latin America, for example, in South America, you have Brazil, Colombia, Ecuador, and Peru, that they are the Andean community, and all the IP provisions are the same because they are regulated by the same IP laws for industrial property and for copyright.
Okay.
For if you go just to in South America, the other countries like Paraguay, Uruguay, Chile, Argentina, they have something called the Mercosur, that they have some law in common. It's not as joint as the Indian community in IP, for example. But one big exception is Venezuela, that Venezuela was part of the Andean community. But when Hugo Chavez was the president, that is the one before Maduro, that is the current president, they went out of the Andean community, and now they are really, it's a very difficult situation because they have, well, you have seen the news, but doing business there is right now is really difficult for the people of Venezuela. You can still do something, but is difficult,
right?
Because they have their IP laws they are really old.
So stay away from Venezuela for right now. Your IP is
unfortunately
not going to get protected. Well, that's understandable, and that's a good point. Because it was like that for years, with China, but they got their act together. So
yeah. So like some particular, I'm not gonna mention all, just the ones that I put in red. For example, one particularity in Argentina, they don't have this mandatory registration in industrial property. For example, for trademarks, patents, they don't have this obligation to register in order to have effect before third parties. In Bolivia, I put here online, but not online, because the online filings are allowed, but then you have to put the papers, file the paper documents.
Are you talking about the license agreements?
Both the licenses and the filing of the IP, or for example, trade.
So the IP, okay.
So this is also sometimes not it may help, because usually with IP filings, there are many priorities that you have to fulfill, many terms, but the online helps for this, but then you have to file the paper documents. Sometimes that's not good, not practical for the client.
Okay.
In Colombia, fortunately, we have online filings for everything, and you don't need legalizations. Everything can be just by email. So this is a good. In Chile as well. In what else? What are the particularity in Paraguay as well? There is not a mandatory registration.
Okay. So I think the important point here to understand, and I think that you brought it out so well, is that while you do have the flexibility to negotiate license agreements in Latin America, there are some important differences in these countries, and that one of the things that has to be done as part of a licensing strategy, whatever country you're in, you definitely do need your kind of legal advice to make sure that the agreements are drafted up and they reflect what's required in the individual countries. And I mean, basically, with licensing, yes, you can get into trouble with it. I've seen that many times, especially internationally. But I think the important point here is you got to work with somebody such as yourself, especially in Latin America. But if you do that, you can be successful. If you do it right, you can be successful. I think that's the important point that people here need to understand, that there is great opportunity down there, but at the same time, you do need to make sure that you do it the right way.
Yeah, that's right. There are many formalities and documentation. For example, in some countries, you need what is called in Spanish certificado de registro de la empresa. That is the certification of the existence of the enterprise. I don't know the term I don't remember the term that you have for this word in US, but it's the permission that the state gives you to have this company, but to have a company. But in some filings or registration of license agreements, the offices require this, and this is sometimes too much. Fortunately, in like in Colombia, Chile, and all this, that they don't ask for legalizations. They don't require this. But yes, the main point that you were telling is that for these countries, for Latin American countries, is not an easy procedure. There are many formalities that you have to fulfill, and the best way is to hire a local expert for these issues.
And I think that covers the next point in the slide deck here, which is that the licensing agreements. But again, we went through all that. And I think one last point, if you can comment on, and that's the enforcement. I mean, in the United States, if you have somebody that uses your trademark or copyright without your permission, you have legal remedies that you take certain actions. If you have a patent and it's infringed on, there's infringement actions that are taken. If you could just spend a minute, or two, just obviously we don't want to get into a lot of the legal details, but how is enforcement handled in Latin America, given all the different countries that you've got there?
Yeah, in the countries that I mentioned as well about the growth, that they are really interested in protecting the IP, like Mexico, Colombia, Argentina, Brazil, Chile, that are the ones that are growing more. I believe that the enforcement is really growing. For example, in the Colombian case, we have specialized jurisdiction for copyright matters, for industrial property matters, that there are judges only handling this type of cases, in comparison to other countries that they just put a judge that studies civil law issues, but perhaps he doesn't know copyright. So sometimes this is a disadvantage for right owners. So we have this advantage in some Latin American countries. Also, for example, with damages, that this is one of the most difficult things to prove in an IP infringement or in different enforcement actions. Some countries, like in the Colombian case, we have also statutory damages that you don't have to prove right now in a trademark case. If you want to, you can do. You can prove the damage in order to take compensation. But right now we have also these statutory damages that just if you prove that the trademark was infringed, you get a percentage on that is established on the law in order to receive the compensation. So this is one of the big advantage. And yes, and from the litigation that I have seen in Colombia and these other countries, it's really growing.
So there's more, as the IP laws are getting better down there, so is the enforcement action.
Yeah.
So it's not a black hole where if somebody treads on your IP, there's no way that you can stop them or get a resolution. They can basically call you and you can help them get a resolution on that. So
actually, for the video game industry that we have handled some, we have helped some publishers to obtain compensation, or at least cease. Of course, the traditional ways is just the cease and desist letters.
That's similar to the United States.
Exactly.
That's the first.
But the judges in these countries, I think that it's they are doing a really good work, and the people and the citizens are really more concerned about this in comparison to 10 years before.
Sure.
I think.
That makes a big difference, and that's really what encourages people to come down there with their intellectual property. So let's move on now as we start to wind this down. Let's just talk about a little bit, finding the right licensing partners. You talked about some of the companies down there. And I think, in general, and I've talked about this before, but really what you're looking for a partnership, obviously, is companies that have the experience and capabilities. And I guess, what would you say, to the participants here at the workshop, when they're looking for partners down there, obviously have the experience and capabilities, but is it something, do they need to come down there? Should they be working with somebody like you? Are there resources they should be looking at to find companies? What would be your recommendations on the best way for them to do this?
Yeah, we are not like the commercial part of the business. Like that, we don't like connect interested in, for example, in having a license agreement in Colombia. We know
Right,
some companies that can make this work. We of course can do all the legal advice in Colombia and other Latin American countries. But the big recommendation also for this in terms of commercial strategies is
right,
that there are many hubs in which I can also connect these right owners, IP right owners. I can connect you with these hubs that I was mentioning.
right. The technology or innovation hubs.
Exactly.
Okay,
Uh, this, and also there is another part of the business that is from Colombia or Latin countries to US. There are so many directories with the franchise opportunities that also there is a franchise guide and franchise registrations, franchise first. Also, there are many associations, like, for example, we are members of the INTA.
right.
Uh,
Into
you can have many right owners, but for the legal issues and legal advice on the licensing, we are really open to help
sure.
the
And I know that on the especially the trademark side, organizations like Lima, the licensing industry, they have the big licensing show that's been going on here in the U.S. It's really spread out. It's now down in Latin America, and it's an opportunity for brand owners, trademark owners to be able to get in front of companies that are interested in doing business. And because it's connected with the U.S. arm, I think there's a lot more. It's a lot more effective way of finding the right kind of companies that would be good partners, and also getting reference on it. Because one of the things that I always talk about is you have to do your due diligence on your partners. You need to make sure that they do have the experience, they do have the capabilities. You have to do some homework. Obviously, discussions help, but a little homework goes a long way in making sure that they are who they say they are and they can do the business. And that leads to the point of, obviously, if you're doing business in Latin America, you got to make sure you can get along with the company. You got to make sure you're comfortable with the folks that you're talking to, and that it's easy for you to communicate with them. I think, in your opinion, I mean, English is a pretty predominant language in Latin America. I mean, a lot of companies speak it. So is there, does the language really present a barrier, or is there English enough that really it can be used to help facilitate the licensing business down there, if you will?
Yeah, of course, that's a big advantage for every Latin American countries, because like 20 years ago, having like knowing English, speaking in English for Latin people was an advantage. Right now, it's not an advantage, but a necessity. So
Necessity.
it's really
Oh,
the
interesting. Okay.
the same. Yeah.
So,
We really have to. It's not an advantage, so we have to do it right now with all this globalized world, and especially now without this pandemic. We need
that's for sure.
to have this the because and also another thing that I would like to mention is the online first, that because we have to cancel. Usually in our firm we go to like 3 different congresses in which we meet with different people from other parts of the world that they like to register IP in Colombia, or we want to register IP from Colombian companies from abroad. But right now we cannot do these congresses or first, so everything is online, and all the congresses are in English, and I don't, yes, in synthesis, I don't find this as a barrier. Of course, we are not fluent, like in my case, but I think that we can we can have an understanding that
Sure,
is not
but
a
it's
big
enough.
issue.
Well, I think that,
Hmm.
obviously that's important,
Yeah.
because communicating is a big part of licensing in terms of sharing information, negotiating deals, things like that. So I think that's something that a lot of people need to understand, that English is not going to stop them from being able to do business in Latin America. In fact, it's something that they're going to be able to do business because of what you just said. English as being more of a necessity now for companies to do business in the world. So that brings us to, you know, one of the last points here, and the best way to manage Latin American partners, I guess, you know, then this goes back to the contract. You know, all licensing agreement contracts are based on milestones and benchmarks and payments, and I think that's holds same in Latin America. But one of the things that you know, I thought you might comment on, you know, inside U.S. licensing agreements, there are contract milestones, quality control, royalty payments. There isn't necessarily any regulation around any of these performance milestones or things like that. But I do understand, and I think I asked you, in particular around trademark agreements in Latin America, quality control is a big issue. And I think, you know, I may have even read that in some countries, they require that there be certain level of quality control clauses inside agreements. Is that what happens?
In the agreement, when you sign the agreement, there is not a problem about this. Of course, you sign all these conditions. Usually the licensor has to put all these clauses in order to guarantee the licensee many quality controls. But so in the agreement, there is not many problems. The problems are usually with health authorities, if it's a health product directed to health. But for example, in Colombia, we have the superintendents of industry and commerce that all the products for health, for the health industry, that they are really checking if they are selling these products on the prices that they should, especially now with the COVID, that the people are sometimes taking advantage of selling one mask in overpriced.
Right.
But in general, the flexibility that the parties have in the license agreement for this quality control, it's really open. There is not such a problem when signing the agreement. The problem can be is after with the authorities, but there is not of course, the parties must guarantee the products, but there is not many regulations on this part. The main part of the regulations of license agreement are the registration of the agreements before the trademark office. But for example, there are not limits on the prices. Usually the license agreement has to be with a price. You can do it for free. That is not of course the costume. But if you do it for free, you have to put it of course in the agreement. You have to fulfill the general requirements of the contract, that of course that the parties doesn't have their will is not vised, not they don't have any for example, if it is prohibited to, but as in US that is prohibited to negotiate with children or something very general, like the general requirements of any agreement.
Right. So, I mean, they have to obviously be competent to enter into an agreement. Yeah. They can't be coerced or anything like that. Very similar to U.S. agreements. You know, and the best agreements are always performance-based. So these three areas of contract milestones, quality control, and royalty payments usually are the focus around them. And I think we addressed the royalty payments. And I guess the same, the question would be in Latin America. I mean, companies that are involved in licensing, they understand, you know, the importance of adhering to the milestones and reporting royalties. And I mean, that's part of the partnership. So the ability to manage it, you have to understand that you got to work with a company that understands that, is willing to do that, you've done your homework on, because that's the only way that you can ensure you're going to have a good partnership and be able to manage it well.
That's right. That's right. That's the main idea beside this.
Well, so, and you know, that just goes back to the fact that there are, you know, there's a lot of things about licensing, and I've said this before, it operates very similar around the world. And I think the point that you fleshed out here is where the real differences come in, or what you have to do, legal registration, contracts, some nuances in there. But I think the fundamentals of how licensing works are the same. And the good news is that means that you can enter Latin America, you can negotiate the deals, you can take advantage of the market, you can bring technologies down there, you can get technologies from Latin America. And it's a market that's obviously closer to the United States. So, you know, for startups, especially anybody looking to expand, it may well be worth a trip down there to see, you know, what opportunities can be discovered. So that really wraps up the presentation for today. I think that, you know, what we wanted to touch on today is what Latin America is, and hopefully share with you and open up your eyes a bit to what opportunities exist, how it works down there, some of the ways that you protect and register IP, and the fact that you can do licensing deals, the innovation hubs, the opportunities that exist down there, the fact that there is a demand for innovation. So I think that for businesses of all size, whether you're a startup or operating business, Latin America certainly presents some great opportunities. And if anybody is you know, looking to get down there, then by all means, I think they need to get a hold of Jose and you know, find out what can be done. So let's go now to some of the questions that we've gotten. And one of the first questions we've gotten is from a company. They want to find distributors for their product. So, and again, I know you're more on the legal side, but if they're looking for distributors, have you got, you know, any pointers that you can give them in terms of where they should go, who they should contact, things like that?
Yeah, it will depend on the industry. I'm just checking the link that they sent. That is Quadra Clicks.
Yeah.
That is from the informatic. Yes. For example, in this, we, as I was mentioning, we render the legal services, but not like the commercial to put the parties in touch. But for example, in this one, there were, for example, with FedeSoft, that is the Colombian Federation of Software. I can ask if maybe they are interested in the. I know that this is not. I'm not sure if it's
software. I mean, but if it's software related, you based on the fact that you have a client, you would be able to get them.
Exactly, because it's informatic industry, so I can help him to search.
Okay.
To.
So I think the best thing to do then is to send you an email direct and have that discussion and see what can be done there. Okay. Next question is, you know, discuss more on how to leverage your IP into new business opportunities is the question. And I think, you know, the answer to that's, you know, one of the opportunities we presented here was Latin America. I mean, the nice thing about IP is it can move anywhere. I mean, provided you have it registered and protected. So when you talk about the term leverage IP, what you're really talking about is going out, bringing it to the market, making money with it. And so bringing it into new business opportunities. And, you know, this is discussed in other workshops and articles, but I think the important thing to understand is if it's got market applications, you can use licensing to bring it into a market like Latin America and open up new business opportunities for it. Because you have to remember your IP is the core of what a product or service or technology is built upon. And so it basically goes back to using the licensing process, the fundamentals of going out, finding companies in the market, doing your homework, reaching out, sharing information. And that's how you, that's the process, if you will, of leveraging your IP, meaning you're reaching out saying, you know, look, I'm looking for licensing partners. And then every time you find a licensing partner, you can build leverage by adding more licensing partners if in fact your IP is a situation where you can put on multiple licensing partners. So we can talk more about that, or if you have more questions about that, go to my website. I have lots of articles on different ways that you can use licensing to open up new business opportunities. Next question is licensing opportunity in Latin America relate to every sectors, including education and luxury?
Yeah, I believe that it involves every sector. For example, if we are talking about education, one recent example that I saw, it was Singularity. I'm not sure if you have heard, but it's from California.
Yeah,
Singularity University, that they filed their trademarks here, and they are doing deals in this for education, and also for luxury. Usually, the Latin American industry, we are not that much luxury producers, luxury goods producer in comparison to US. So this is a big opportunity, because if you, for example, enter a mall here in Colombia in one of the main cities, many of the stores are from luxury goods, but they are foreign stores. So this is why I believe that there is a big opportunity to license, because usually the trademark owner, they don't settle a company here. What they do is they license their trademark and they find a distributor to sell their products here. So, but in these two industries, in special education and luxury, I believe that the opportunity is really big. Usually Latin American products are more agricultural, I believe. For example, from what we export in the Colombian case is coffee. For example, we recently filed, one of the ones that I remember is San Alberto coffee. That is a Colombian trademark, a really luxury coffee that we filed the trademark recently in the US. But it's more agricultural products rather than education or luxury.
Okay. So, and again, if you have more questions on that, feel free to reach out to Jose, and he can delve deeper with you into that. So I think with that, we're going to wrap it up here. I'd like to thank everybody for joining us. We really appreciate you taking the time. Hope you've learned something, gotten some value, got a chance to meet Jose, understand more about the Latin America market. Up there on the screen, you'll see our contact information. Feel free to reach out with any questions, any follow-up. Be happy to answer those questions, see how we can help you out. And also too, this workshop will be available for a replay, so you'll be able to get a hold of it and view it again if you like, to find out if if you missed anything, or if you got any further questions on that, or you just need to refresh your memory on it again. It'll be up there. So thank you all for joining us this afternoon. Have a great rest of the evening, and I look forward to seeing you again back on another licensing consulting group workshop. Good night, ladies and gentlemen. Bye-bye.